But for last 25 days,
How many days?
25 days, I do not find anything subject of your lordship whether further custody, purely civil matters, ma'am.
No, civil matters, but allegation is something
I
different.
am diving of the main person.
Because
Nothing.
taking away from the police custody.
No.
Huh?
No, nothing, ma'am. Page, your lordship, page 11.
Where is the FIR?
Page 11, ma'am. Banakula is page 18.
Page 11.
Page 11.
This is the FIR?
Yes, ma'am. This is it. In between there might have someone, Kulennath, that case is also coming tomorrow, your lordship, might have. But here is a case, madam, he is a driver of Mr. Kulennath. Titles will go pending, madam.
That we have seen.
Injunction already dismissed. Appeal pending before us.
I think others are we have granted.
Lordship.
Two persons, day one we have granted.
Here only the thing is that Lordship, this
He's the
person
main
is the
accused.
FIR name.
FIR name.
FIR name.
Those were not FIR name, even the
Those were not
forwarding
FIR.
report also
Yes,
their names
those
were not
those
there.
Not FIR.
That we recall.
Yes, Lordship.
25 days letting
SDGM Dawang Mangal.
SDGM Dorang Mongol. The paragraph of the developer civil. 6 and 7. Supplementary list note, my point. Okay.
Today is for
How many days?
2 years, 2 months.
2 years, 2 months. What is the present status?
Lordship, in this matter, Lordship has called for the
Now we have got the report.
report.
No. Your report. Okay.
Yes, Lordship.
That report is here. From the registry, we are having it.
Lordship, here one is from the ADGP CID regarding their part regarding the policy, and another one from the police headquarters from the it is the AIGP law. That is in the same is there, only the general part is there if it is not looked after by the CID. To make the presence of the PWs, Lordship. That was earlier query.
Okay, we'll take this part, we'll take a little bit later. Let
Lord.
us see the bail application.
Lordship.
These are the additional things. Yes. Where is the FIR?
Where, my lord, page?
Page 13, Lord.
13, my.
Huh?
Page 13.
1-3.
1-3.
1-3. Yes.
May I read?
What is your name?
My name is Shamim Ahmed Borgoya.
What is the earlier bail of other
Earlier, my
accused?
lord, page 35.
You approached anticipatory, that was
No,
rejected.
No, earlier, 439.
Earlier also 439.
439.
Okay,
Directed to complete the trial within 6 months, 8/11.
okay. Ah,
Page 36, last paragraph.
how many witnesses examined?
Lordship, 3 numbers of witnesses were examined.
3 numbers of
Witnesses were examined till 4/1/2024. Rest part,
total.
total number of witness, Lordship, it is, Imam Asali?
14, my lord.
This is scan copy.
A scan copy is there, Lordship. But it is available up to Lordship, 4/1.
Anyway, just tell us, so what is the total number of
14 PWs.
14 PWs? How many examined?
Three.
Examined on the earlier stage
Earlier
when
stage,
bail was rejected.
two,
When bail was rejected,
8/11/23.
bail rejected on 8/2023.
11/23.
3, Lordship.
Page 35.
Page 35. Now, on that day, how many witnesses were examined?
On that date, two
2 numbers of witnesses were examined.
2. Now, thereafter, till
There-
now,
Thereafter, Lordship, 2 numbers of deaths were given. One on 28/11/2023.
Hmm.
On that particular day, Lordship, PWs were absent and the fresh summon was issued.
Hmm.
And next
so
date
let,
was
let us tell us 2, then matter was fixed on 2,
28/11/2023.
28/11/2023, no witness.
No witness were examined.
Okay. No witness present.
No witness present, Lordship. So summons were
Issued again.
issued fresh. Yes,
Again,
Lord.
next,
Next date was, Lordship, 4/1/2024.
4/1/2023
24, Lordship.
or 24.
Yes, Lordship.
Then what happened on that day?
On that day, PW3 was examined,
PW3 examined.
Lordship.
Then,
Lordship, in the LCR, up to that.
and thereafter,
Thereafter, my knowledge concern, another 3 were examined.
when?
When, my lord?
That is what I have asked you on last occasion. Give the up to date. In the NDPS case, seeking bail and not having information will be difficult.
W5.
Oh. 6 months, which order, by which order it was directed, it should be completed within 6 months?
This is my lord,
Page
page
35.
35,
Okay,
page 36, last paragraph.
30 months. Okay, then now tell us the after 4/1/2024.
PW5, my lord.
PW3, now PW4.
PW4, Anuram Rajvanshi, my lord.
When?
Civil witness.
Date?
My lord, kindly fix them tomorrow, my lord. I will give all dates and everything.
See, this bench is not a regular bench. You want a
Then
bail
kindly
and
fix it
on
tomorrow.
last occasion also I said that
Kindly
please
fix it.
get your information up to date.
Kindly fixed at 2, my lord. At 2 today, my lord. At 2. I am giving a block.
Come prepared, huh?
At 2, my lord. At 2, my lord.
At two. We'll see, report will, that is a different
Yes, sir. So
aspect.
that is regarding the policy and.
Policy.
And,
We'll see that
and
what
the justice
to be
delivery
done.
system also.
Yeah, what is the mistake?
The paragraph 8 of the judgment, instead of EESO, it should be PESO, Lordship.
Where paragraph 8 of the judgment?
8 of the judgment. That will Lordship find at page
12.
page 14, Lordship.
E instead of EESO.
It should be PESO. Lordship will find that in page 14.
Paragraph.
Petroleum and Explosive Safety Organization.
Okay.
And one Lordship, my license is valid till 25. Lordship will find it page 15. So instead of renewal, should be restored, Lordship. That same paragraph.
Okay, it should be restored.
Because my license is valid till 22/8/25. Lordship will
No,
find
no,
it
we have given accordance with law for renewal and continuation of the.
be restored, Lordship,
No,
because
we have given oblique.
Lordship,
There is no problem. Either it may be renewal or continuance.
continue.
It is continuance is there.
Lordship.
That I do not think it's a correction. Is required.
I'm insisting, the IOC is insisting.
Why who are you representing IOC?
Melo.
What is the problem? It's less. Either way,
Melo.
advise your client.
Melo.
This is not the way.
I'll do.
Advise your client. This is, it cannot be said as a defect. We have given two options. Either if it is a case of renewal, or if continuance, continue. That's all. Heard Mr. Chakraborty, learned counsel for the petitioner, and Mr.
D. Bora Melo.
D. Bora, learned,
Appearing for Mr. P. Bhardas.
appearing on behalf of P.
Mr. N.K.
Bharaddas,
Chaudhary or P. Bhardas.
P. Bharaddas for IOCL.
Melo.
IOCL. The present application is filed for correction of a typographical error which occurred at paragraph 8 of the judgment of the order dated 15/3/2024 passed in IA Civil /3483-2023. Full stop. What is called P?
PESO. It should be PE,
Petroleum.
Petroleum Explosive Safety Organization. PESO. Lordship will find it page 14.
Page 14.
Top, at the top.
Okay.
After Ministry of
Okay.
Commerce and Industry, then
Okay.
Petroleum and Explosive Safety Organization.
Petroleum, no, comma, लिखिलो पुलिस last letter so full stop. The word PESO, peso, within bracket, capital PESO, has been typed as EESO instead of PESO. Full stop. Accordingly, the said typographical error be corrected and the aforesaid word EESO at line 2 of paragraph 8 of the order dated so and so be read as PESO. Full stop. PESO. Full stop. Though Mr. Chakraborty has submitted that the word renewal / continuation will not write it. Full stop. Accordingly, the present application stands allowed by making the aforesaid correction.
Obliged.
Dispose of. Yes.
Wait, Mr. Lordship.
There is some note about it.
Your Lordship, may peruse the order dated 21/3/24.
20.
1/3/24.
Yes, yes.
Your Lordship. In this matter, K. Chaudhary is appearing to virtual mode.
I have seen. Okay. Yes,
Ultimately, the question has to be answered by me only.
yes, yes.
But because Lordship on the last occasion has pointed out to the judgment of GNRC also,
Hmm.
Lordship had recently passed. There, now I don't have to show to other judgment because Lordship itself in the judgment has held that on certain occasions when alternative remedy is not a bar. And I will be mostly relying on, rather than going into fundamental right and other aspect, mostly on the issue of jurisdictional part, whether ESI during that point of time in 2009-10 could have raised this demand against the petitioner under the ESI Act. Now, the entire argument on the last occasion concluded on the point that hotel will be considered to be a manufacturing entity, and that's why it will be treated to be a factory under the ESI Act as held by the Honorable Court in 1993. So I was supposed to answer on that point because if hotel falls under that category, then anyways the ESI will have a jurisdiction. But then if hotel does not fall under that category, then whether they will have a jurisdiction for that particular period when hotel was not even brought into force under ESI Act. That will be the ultimate question which I'll have to answer. Now for that, my lord, I'll just have to show a few, firstly the ESI Act.
No, just before that,
Yes, my lord.
suppose we have, we have not made out any mind.
Yes, my lord.
We are open. We are
Hmm.
open. What we have, we are good. We have recorded.
Yes, my lord.
Now the question is, suppose, just also keep in mind, suppose whether at that relevant point of time, the ESI, the hotel can be said to be a factory or it will come under ESI because of that kitchen, all these different definitions. Whether that factual assertions can be made in this petition so as to hold that this is not within a factory, so therefore ESI will not be applicable. Or to say that there must be 20 employees or 10 employees, you are not having this much of employees, can be ascertained or determined in this proceeding, or it should be better, even for your interest, to get it determined by a competent court. Can't that be raised in a competent court saying that, see, this is, you don't have a jurisdiction because these are the factual aspects. So these factual aspects can very well be determined by the ESI court. then if it is decided that no, at that, because this will require an assertion of all this return or all these records, is not it? That whether it was 20 employees, 10 employees, whether it was
Yes, sir.
factory, kitchen or not,
I'll answer to
that
that.
aspect you also address.
Correct.
Because it is your assertion that this for this reason, we will not come under the Factories Act.
Correct.
And that assertion ultimately involves certain factual assertions. Isn't it?
No, my lord, facts,
Okay. Hmm.
which is admitted. I'm not
Uh-huh.
saying something where there will be requirement of a finding of fact.
Okay.
Admitted position. In
Admitted position, of course. If it is an admitted position,
Yes,
we
sir.
can very well, we can take
I am
note.
not pleading here anything to say that we did not have a restaurant.
Okay.
There is no pleading as such in my petition
Hmm.
also. I have not said anything that there was no restaurant. So whether it will fall under factory or not will be a factual question to be decided by the ESI of that period, which will be impossible also at this stage in 24 to decide whether in 2009
Ah.
there is a restaurant or not. It will be very difficult for everyone to ascertain.
Okay, so therefore you are free to argue.
Yes, madam.
Not that we have expressed some mind. We are starting afresh.
No, I'll just clear on that confusion of your lordship, whether it will be factual. Even on the employment part also,
Okay.
I am not putting anything of my facts that we did not have 10 or 20 employees.
Okay.
It is their own show cause notice which says there were 11 employees.
Hmm.
I'm not going beyond that.
Okay.
11 employees, whether on 11 employees they could have raised the demand or not during that period.
Hmm.
That is the only aspect. And
Okay, suppose, so your whole case is that they don't have a jurisdiction
jurisdiction.
to proceed against you. Therefore, you have filed this case. And his case is twofold. One is under 226(2).
And there is not only initial object maintainability.
Ah.
Whether we are not, I have not yet argued on the merits of the
No,
facts.
we'll go, not merit.
No.
So merit, he will argue
No.
first. So your whole contention are two plank. One is that this court will not have a jurisdiction because all cause of it, there is no cause of action within the jurisdiction of this court. All the cause of action in Tripura. This is one. Second aspect is that
Maintainability.
even if it is,
মানে
if this court is having a jurisdiction, then also these issues are to be, there is an alternative efficacious remedy against them. Therefore,
no.
court should relegate him.
No.
And his whole plank of argument is when it is a question of jurisdiction, the bar of alternative remedy will not come. This
Right.
is your case. And then you will, because this is your whole case.
Hello.
According to you, you will not come under ESI. So why should we face litigation before the ESI?
Yes, ma'am.
And
Ultimately,
on 226(2), what will be your argument?
My lord, I have recorded also in the last occasion that recovery officer who has issued and recovered the amount, he is from Guwahati. In fact, their entire Northeast head office is in Guwahati, Bamuni
Okay.
Moda.
Hmm.
So there is a document which I have annexed. The primary cause
So
of action
recovery order was issued from here.
issued by Bamuni Madam. So cause of action, there are
Partly here.
Yes, ma'am.
Okay.
Hello.
Okay, now let us proceed.
Mala, I'm just take 1 second of your lordship. Yes, ma'am.
Yes.
Sorry. So, my lord, on the last occasion, now ultimately, what
Just a minute.
am I a bit audible?
Your volume is a little bit low.
Okay, my lord. I'll have to. No problem. I'll come closer. Is it audible now, my lord?
Now, otherwise it was audible, but see. No. Okay.
My lord. So now whether I will have to again place on the point with regard to that recovery order, or my lord will want me to.
No, you argue afresh. Thus, we have recorded. This will help us.
Yes, my lord. So firstly,
We understood the point of maintainability and all. That
Yes,
that
sir.
part we are allowed for the time being a little bit keeping aside. Let us hear him why he is saying that there is no jurisdiction.
jurisdiction part I'll explain. Yes, my lord.
That is what, because this is your whole case.
Yes, my lord.
We cannot determine all those factual aspects except the jurisdiction.
Restaurant, I'm not claiming anything that whether I had restaurant or not.
Hmm.
Even after having a restaurant, whether it will fall
No,
under
your
factory or
basic
not.
ground of challenge is the jurisdiction,
Yes, my lord.
is not it?
If I fail before your lordship, then of course, and I'll pray before your lordship that lordship will give me the liberty to.
No,
appeal.
that we understand.
Different.
Suppose we say that
Yes, sir.
in the given facts, you will have an efficacious alternative remedy. Of course, you
That-
will
Yes, my lord.
relegate it to you.
Yes, my lord.
Before that, since you are raising that alternative, you also admit that there is a provision to agitate your grievance in a court. Had it been under ESI, your whole case is that I will not come under ESI, so therefore this is not an efficacious remedy.
Yes, ma'am.
I question their jurisdiction. Is
Yes,
that it?
ma'am. Yes, ma'am.
If that be so, this is the case.
This is ma'am.
But as per section 75, my lord,
Huh.
whether even if he doesn't suppose he success,
No, understand. Your case is that even that point of jurisdiction can be determined by the
my lord, the court.
the
That is
court.
my.
That is your
internal.
yes. Okay, let us
So,
rephrase it.
Yes, my lord. So first of all, my lord, I'll just show the so-called notice which is in page 20 of their affidavit in Radha International case. That will be
Radha
4139.
Hotel Radha International. So
4139.
what are the difference between all the factual
Ah.
difference between all these cases?
Yes, my lord. One Radha International. There are two.
No, no.
Radha
Can we, if we deliver a judgment, can we pass single judgment
No,
or
there will be one difficulty.
Hmm.
This hotel and restaurant is applicable only with respect to Radha International.
okay?
For Gemini Distillery,
Hmm.
it is otherwise falling under factory. There, my line of argument is different. That which will also apply to Radha International also. That on the date when this act was not even made applicable, can you have visited the premises and had instruction or knowledge about the employees, and then after 4 years raise a so-called notice and demand for a period when the act was not even applicable? That was in the 2008.
That is also a question of jurisdiction.
That is also a question of jurisdiction. In
But
2008,
factual aspect is that factual aspect is one is hotel, other is distillery. How many
Distillery-
hotels are there here?
three cases are there.
See, two are distilleries.
One is distillery. Radha International, what happened? Firstly, they raised the so-called demand. And second one is for penalty. For not paying the amount, they
Okay,
also
so we
charge the
can
penalty.
take both Radha.
And
together.
Gemini Distillery. Radha, both lordship can take.
Okay. So therefore, we will go to the facts in sequence of events, how the first it is present
Yes.
and
If
how
I-
the second.
If I succeed in 4139, that's the first of Radha International, then second one automatically will help me. That will follow. It's the same issue, same facts, only the damage was claimed in the second
Okay.
petition.
Let us just আপনি যাও, না থাকিব। যে dictaphone. Yes,
Yes, Manoj. Manoj, affidavit.
just let us recall our facts.
Okay. The facts is, my lord, very simple. In
Yes,
during the year 2012, a so-called notice was issued to the petitioner.
2013.
2000 from 2012 only. 2012 was the first so-called notice.
Where do you get that?
That we will, Lordship will get in page 20 of the affidavit in opposition.
20 of the affidavit in opposition. 20 of the affidavit in Radha International. Okay,
4139.
yes, 14. Page 20, na?
Annexure F.
Okay.
This was the first so-called notice. If your lordship sees,
1/10/2012.
yes, my lord. And this so-called notice was issued for a period from January 2009 to August 2012.
Where do you get that?
That lordship will get in the bottom of the page 20. That you have not so far paid the contribution as per provision of the law and have also not submitted monthly details of the contribution. And
From January 2009 to
August 2012. And
Wait.
in page
just a minute, just a
51,
January 2019 to March 2012.
2009, my lord.
But here
January-
this
January
January
2009.
2009 to March 2012 at the page 20 Annexer F.
Yes.
Last one is
Last.
March 22.
August. No,
2012.
August. Next page also it is there. August 2012.
Okay, okay, August 2012. Okay. Hmm.
And in para 4,
Hmm.
I have mentioned number of employees, 11
There are 4.
in the table. Number of employees in this serial number 4, 11.
Okay.
So that is why I said that I will not be saying anything beyond what they have issued in their show cause notice.
Hmm.
And my lords may kindly
Okay, so therefore, it was issued on, first notice was issued on 1/10/2012
yes,
for demanding payment of contribution
absolutely.
with effect from January 2009 till August 2012.
Correct.
Okay.
Now my case,
And in that notice,
also my lord may see
in that notice, it is also reflected that total number of employees
are 11.
in whose, against whom the contributions were to be given are 11 in numbers. Am I correct?
Ma'am.
11 in numbers. Okay.
Then my lord may also see para 3.
Para 3. But
That,
it says
that you have failed to produce relevant records of contribution payable before the issuance inspector who visited your factory establishment on, they don't mention the date
Hmm.
in the show cause notice.
paragraph 3, though, says that petitioner have failed to produce the relevant records of contributions payable before the insurance inspector who visited the factory. However, date was not given in the notice. Kindly see whether any date is there.
It
on
is
your
there in
record.
the affidavit. I will show
Yeah.
it. It is
Okay.
there in the affidavit. In the show
Hmm.
cause notice, it is not there. They have mentioned it in the affidavit.
Mm.
But-
Though a mention is made in the affidavit to the effect that notice was
Carried out on 2012,
visit was made on,
2012, 2008. In
where
page
do we
2,
get it? 2012,
2008.
where do we get it?
Page
Page?
2, page 2, bottom.
Page
Last
2
sentence.
bottom. Visited on 2012, 2008.
Eight.
And on inspection, it was found that petitioner employed 11
11.
employees.
My lord. Then my lord may kindly see again the annexure.
Hmm.
That was in their first annexure A.
Page 14.
Yes, ma'am.
Okay.
Now,
Hmm.
in this annexure, they say that ESI Act will come into force in state of Tripura on 1st January 2009.
Just a little. A notification under subsection 3 of section 1 of the ESI Act 1948 was issued appointing 1st of January 2009 as the date on which the provision of chapter 4 within bracket except section 44 and 45 comma which have already been brought into force bracket close and chapter 5 and 6 except subsection 1 of section 76 and section 77, 78, 79 and 81 which have already been brought in force of the said act shall come into force with effect from 1st of January 2009. Okay, then
Then comes the second notification that my lord, if in my case it is typed. Here it is
It-
not bit clear.
page 15,
Page 15.
Hmm.
That was of 2010.
16th of March 2010.
Yes, my lord.
Notification 16th of March 2010.
Yes.
Yes.
Is
What is
it
this?
legible for your lordship from this?
Readable.
So it says in schedule 1,
Hmm.
the following establishment wherein 20 or more persons are employed or were employed for wages.
Just a minute. Just I am recording your arguments and facts
That is very helpful.
together.
Yes,
Huh.
madam.
If any mistake is there, please correct me.
Madam.
Subsequently, notification dated 16th of March 2010 was issued by the Labour Department, Government of Tripura, in exercise of power under subsection 5 of section 1 of the ESI Act 1948.
Fifteen 2010 is the appointed date.
Whereby 15/3/2010 has been declared as appointed date on which all the provisions of the ESI Act shall extend to the establishment and areas specified in the schedule of the notification dated 16th of March 2010. Okay, now what is your case? Which notification?
In that first notification only, in
Hmm.
that notification only, in the
Hmm.
serial number 1,
Hmm.
hotel and restaurants
Hmm.
having 20 or more employees have been incorporated as an establishment.
Okay. By the said notification, amongst other, hotels, restaurants, hotels and restaurants having 20 or more persons being employed or were employed for wages on any of the preceding 12 months are brought under the aforesaid act. Okay.
Hello.
Hmm.
Now,
So what will be the preceding months? 12 preceding months
12 preceding month
from 15/3.
on 15/3.
So it will be 15/3/2009. Isn't it?
Yes, sir.
Okay. Is it correct? Yes. Yes, next.
On any of the preceding 12 months.
So employment must be more 20 or more in any of the preceding 12 months. That is from 15/3/2010. Okay.
Hello. Then
Hmm.
comes
Hmm.
the second notification,
Hmm.
28th July 2011.
Okay.
Here they have appoint 7th July 2011 as the appointed date and change it from 20 to 10.
Okay. Yet another notification was issued on 28th of July 2011. In exercise of power under subsection 5 of section 1 of the ESI Act 1948, appointed 7th of July 2011, bringing certain institutions under the purview of the ESI Act. Isn't it?
Yes,
Full stop. In terms of the schedule of the aforesaid notification, Where is that?
My lord, schedule.
Hotel, restaurants, etc. Where is the employee?
In the top only, in the schedule, the following establishment wherein 10 or more employees are.
Where?
My lord,
10 or
in
more, where do you get it?
schedule from in the schedule in the page 16.
Page 16, schedule. Description of establishments, areas in which
Yes, the following establishment below description
following
is
establishments, okay, establishments were brought under, where 10 or more persons are employed or were employed on any day preceding 12 months, that is from
Seven-
20th of July,
7
from,
July 2011.
3rd of July 2011. Published on 3rd of July. Is that it?
7 July.
Oh, no. 20, when it was 20th of July.
28th of July, the notification came.
And what is the date
Date
preceding?
of appointment as 7 July 2011.
Okay, from 7th of July. Okay. 7th of July. Okay, sorry. 7th of July 2011. Okay, then. So,
Now-
according to you,
My lord.
first came in 20 employees,
Yes.
is not it?
Yes.
Then date of effect is
2010.
date
15th
of effect is
March 2010.
just a minute.
Page 15.
1510. So it will be 9. 12
15
preceding months.
Yes. 15/3/2010. So 12/15/2009.
Oh.
But for 20 employees.
15/3/2009. Okay. Okay. Now, and second notification, 10 or more. It was 7th of July,
My lord.
2011. 7th of July 2010, isn't it?
11.
11 preceding 12 months.
2010. 2010. Yes.
12 months preceding 12 months.
And Lordship may also record the date that it came into force on 1st January 2009.
Where is that?
That first annexure 14, the entire act came into force in 1st January 2009.
Oh, Act came into 2008.
1st January.
Act 1/8/2000.
1/1/2009.
1/1/2008, isn't it?
Yes, ma'am.
Hmm.
And they carried out the inspection on 20th October 2008.
28th of
20 October.
October 2008. So therefore, after coming into effect of the Act, oh no,
No
2009,
inspection
isn't
was
it?
carried.
2009.
No inspection is carried out to show that preceding 12 months there were employees. And in
So
2012,
can we sum up like this?
Yes, ma'am.
Just like the Act, ESI Act, thus the ESI Act was, whole of the ESI Act was made applicable with effect from 1st of January 2009.
Hello.
2009. The inspection was carried out on 28/10/2008. Isn't it?
2012, 2008.
2012. 20 October or December?
December.
28th of December 2012, 2008. Hotel and restaurant initially was brought under the incorporated in the schedule on 15/3/2010 with effect from 15/3/2009.
No,
Not
my
with
lord,
effect?
that will not be with effect from
Not with-
2009.
Okay,
That will be like,
15/3/2010.
huh, counting has to be on the preceding 12 months, not with effect from
15/3/2010 and subsequent notification reducing the number of employees was brought into effect on 7th July 2010.
11.
2011. One is 2008, other is 2011.
One is 2010,
One is 2010,
the other one is 2011.
other one is 2011. Okay. 15/3/2010 and 7/11/2011. Okay.
Now,
Hmm.
first of all,
Hmm.
on when 1st January, this entire act was brought into force.
Hmm.
Before that, they carried out an inspection.
Hmm.
Now, how many employees were there or not? I'm not admitting anything that there are 11 employees or not. That's a different fact altogether. But at that time,
Your whole case is that you did not have any jurisdiction
Jurisdiction
even
that day.
to visit our premises.
yes,
on
and that
day.
is why it is not reflected in the so-cause notice. They don't even write it in the so-cause notice that when they carried out the inspection. That's absolutely arbitrary. And when the so-cause notice was issued, it was issued in 2012,
Hmm.
again after 3 years.
Okay.
So in 2012,
Hmm.
how do you arrive at a figure that they had this many employees in when 20 more employees were to be there? They have this many employees when 10 more employees were to be there. There was no finding at all. They have never visited my premises. And it is apparently clear from their own record that there is nothing on record to show that they visited my premises.
Suppose we
during that
admit
period.
that they have visited, what will be your argument? Suppose we assume on what they have said we have visited.
Yes,
On
sir.
28th of December 2008.
8. No, that day I'm not disputing. That day I cannot dispute because the moment I factually dispute something, that will be
Yes, so they
problematic
have
for me.
admitted. So therefore your case is on that day,
They could not have.
even you don't have no jurisdiction has been conferred upon you
Yes.
either under the act or the notification issued to carry out such an inspection.
And how many employees were there is also not subject matter of the issue that during that period of time.
Mm.
That was the first argument.
Mm.
Then from 2009, since 2009, you are asking for my contribution.
Mm.
It came into force in 15/3/2010.
Mm.
Hotel and establishment. I will explain that definition, that Supreme Court judgment. I will explain that part separately. But firstly, they on their own document they brought hotel and restaurant into force in 2010.
Mm.
So now can they show that they are asking this insurance contribution from all the hotels or separate only individually they are selecting me? Because 2009 there was no applicability of the act for hotel and restaurant. Then from 2010 to 2011, 11 employees, they could not have raised the demand.
Okay, then.
Madam, kindly see so-cause notice, it's from January 2009. So January 2009 to 15/3/2010, they could not have charged it. Then from 15/3/2010 to 7/11/2011, for 11 employees, again they could not have asked for the contribution because that was for a period 20 employees. 10 employees came after July 2011.
So let us now compare with these notices.
Yes.
So first notice demand was from
January 2009
January 2009
to August 2012.
to August
2012.
2009.
12.
August 2012.
In
So
one,
according to you, they cannot demand up to 1st of January 2009.
from 1st January 2009 to July 11, 2011.
July 2011, when it is 11, they could not have demanded
Yes, ma'am.
because they themselves said it is 11.
11.
Whereas at that point of time, it was 20 or more.
Yes,
This is your case.
correct, ma'am.
Now, and what is the, what about the other parts?
My lord, other part, I cannot, as they have included it as a whole,
Hmm.
now it cannot be separated.
Hmm.
Either they'll have to raise a separate demand, or if when they have brought a demand with respect to a period for which they don't even have a jurisdiction, I have a liberty to question the entire so cause notice as a whole. And rest of the part, if they wish, they can very well raise a demand, but for that they'll have to have record also, information. Now they cannot rely on the information of 2008 to say that for this period they will raise the demand. They don't have any information for that period. And they've never asked for me. They've never asked from me anything on for that period. And same applies. There is another so cause notice, second so cause notice, that is for a
Page,
second so cause notice is in page 28 of my writ petition.
page 28.
Yes, ma'am. September 2012 to September 2013. Again, number of employees 11. I'm not disputing on that, but they are going by the.
Okay, I'll come back at 2.
My lord.
Try to try to do something your voice because it's I think
Not-
speaker is at distance, I think.
No, my lord, my maybe laptop has got old. I need to change it then. It's not true.
Better you change it. Technology,
Yes,
the age
my
of
lord.
technology.
I know, my lord, sir. I'll have to look.
Today
it.
we'll continue because today we have time.
Yes, my lord.
Prepare the short notes.
Yes, give us. Got it. So total 14 witnesses. Bail was rejected on 8/11/2023.
Prepare the short argument.
At that point of time,
Two numbers of witness were examined.
okay.
Examiners.
Can you have a copy of this
Yes, I
witnesses?
have given this. Yes, I have given all the copies.
Okay.
1 and 2 is annexed and 3 to 8 I have given just.
Okay. 4 to
3 to 8.
3 to 8 is annexed with the
1 and 2 is annexed with the petition. And 3 to 8 just I have given now. With these arguments.
okay. You are Sami Ahmed Borvia.
Sorry, Mahmood.
What about Habibur?
Habibur, he is the council.
In the next petition. Huh?
Last.
Hmm? Hmm. Hmm. Who is PW6?
PW6 is my lord. PW is Ajay Das,
Who is he?
who is the Caesar witness.
Yes, bad case.
My lord, there are some discrepancies is there.
Some discrepancies where?
These are witnesses, my lord. In respect of Caesar witnesses, my lord. Discrepancies is there, my lord. Sometimes they said they did not see the, when the signatures were put,
Not at this stage.
and 2 years, 2 months, my lord. My lord,
We cannot also say that trial is not proceeding.
but what my submission, my lord, the 6 months stipulated
Who
period,
are the other witnesses?
other IO is there, my lord,
ION,
and some other.
forensic. ION forensic.
Forensic and some other persons. This Suraj Datto, Nandakumar Sinha, SI,
Nanda Kumar Sinha is the subsequent IO.
Shyam Goswami,
That will be the, I think, forensic.
Forensic.
I do not think any other
Pranab
witness.
Mili, IO is also, my lord.
IO last.
Yes.
IO is that Mili.
Really.
Mili and
Subsequent to IOs during the
subsequent
yes.
IO and
Forensic officer.
forensic. That's all. Nothing is required.
And it is progressing after the court order of this honorable court. Yes.
Within that 6 months, my lord, only 5 were examined. Total. And within this, after passing of this order, within the 6 months stipulated period, only 3 were examined. So, my lord, in that respect, my lord, considering that aspect, my lord,
No, that we understand. We understand exactly, but the materials available
No.
nowhere come close to the satisfaction of 37.
Caesar witnesses is little bit different.
Which are the Caesar
Sir,
witnesses?
please.
1 and 2.
1 and 2 and 6.
1 and 2.
One and
6,
two.
what is the discrepancy in 6?
1 and 2 is discrepancies there. And 6, my
1
lord,
and who are 1 and 2?
1 and 2, Bapon Rai and Siddharth Malakar,
What do I say?
my lord.
That you were stopped at the checking point and this Yaba tablets were recovered has all everybody has said.
Quantity, my lord, 200 grams. And recovered from 2 persons. 2 separate motorcycles. 200 grams. Although, my lord, it comes under the commercial. But, my lord, only 200 grams. And 2 separate motorcycles, 2 persons, 2 vehicles. And we see my decision is 200 grams only.
Give your point of argument. What are your arguments? Just will record your argument. First is that 2 years, 2 months
2 years, 2 months.
delay in trial, is not it?
Yes, ma'am.
For that you rely on those judgments.
Court order is 8/11/23. This
Okay.
court's order 6
Now, even after this court order 8/11,
23.
2023,
6 months stipulated period.
Hmm.
This is. And quantity, my lord, 200 grams.
200 grams or
200 grams of Yaba tablets. Recovered from 2 parcels who were in 2 separate.
200 tablets,
Yes, my lord.
2000 number of tablets.
2000
200 grams. My lord, may I read first of all
Gram
the
is
FIR?
gram is 200.
My lord, may I
gram is 200.
Gram is 200. The
My
number is
lord,
2000 numbers.
may I read the FIR, my lord?
Yes.
The recovery from which persons,
Hmm.
that was also not confirmed, my lord. The persons, 2 persons, 2 separate motorcycles. May I read my lord FIR?
Read it. Where is the FIR?
FIR page 13,
Page
13.
13.
There was an urgency of conducting detention. This is to inform if that reliable information was received by me at 4:30 PM today, that is on 15/5/2022. As per the information, a large quantity of suspected to be narcotic drugs is being transporting from Katigora to Badarpur area via Badarpur Ghat in 2 numbers of bikes so and so. There was an urgency of conducting
So
detention.
these 3 are Caesar witnesses: Bapon, Siddhartha, and Ajoy.
Some unknown places in no time. Hence, authorization from a gazetted officer as per section 42 of NDPS Act could not be obtained, my lord. This is the first point.
Hmm.
Could not be obtained for conducting detention and search after sunset, my lord.
Hmm.
So it is presumed that the it was done after sunset. Because
No,
authorization is
no,
not.
presumption will not come.
Yes.
Let us see what is the time.
Gazetted officer as per section 42 of NDPS Act could not be obtained for conducting detention and search after sunset. As it was believed that such authorization could not have been obtained without affording opportunity for concealment of evidence, facility of escape of offenders, and removal and transportation of NDPS substances. Ground of such belief was recorded by Malwa PICP GD number 204
So
dated
that has been
15
recorded. That has been recorded. When there is a scope, emergency, you'll have to record it, immediately do it, and subsequently
Yes, sir.
it will have to go. That stage, whether there is a mistake or not, has not come yet again because you'll have to cross-examine the IO. So whatever is there on the basis of seizure, we'll have to take a call at this stage.
So my lord, my lord, so it
Whether
has to-
there is violation of 42 or not, those will come through the witnesses of the IO.
Yes, sir.
They will have to exhibit
Hello.
this GD entry and everything. Then you will have a chance to cross-examine.
ground of such belief was recorded by Malwa PICP. Then I, along with the belonging police personnel headed by me, left for Badarpur Ghat on 15/5/2022 by GD number dated 15/5/2022. So and so, Amir Hussain, Constable Samir Chaudhary. I, along with the aforesaid police party, arrived at Badarpur Ghat by our GOV vehicle, Tata Sumo bearing register number so and so, driven by me. At 4:40 p.m., we started for Badarpur Ghat and intercepted two numbers of Pulsar bike bearing register number so and so and register number so and so, in which the two suspects, namely Shamim Ahmed Borbuya, son of so and so, and Habibur Rahman Borbuya, 24 years, so and so, were coming towards Badarpur Ghat. Before starting the search, we had called three independent witnesses of the locality who were present nearby to witness the search process and explain the purpose of search. The witnesses are Bapon Rai, Siddharth Malakar, Najoy Das. Present address, Paskram, so and so. We identified ourselves and also offered themselves to be searched by the independent witnesses before starting the search of the bike bearing register number so and so and bearing register number so and so. The two suspects person, namely Shamim Ahmed Borbuya and Habibur Rahman Borbuya, so and so, so and so. I have asked the suspects and informed that their body will be searched and whether they are willing to be searched at the place or desire to be searched before a magistrate and issued notice under 50 of NDPS Act explaining it to them. They have not objected their search at the PO, and I started the search of the persons, namely Shamim Ahmad Borhuya and Habibur Rahman Borhuya, Kachar, in presence of above mentioned witnesses while complying with the provision of section 42 of NDPS Act. The following items have been recovered by me from the possession of the suspected person concealed inside there. 10 numbers of small black plastic packets, each small one contains 200 tablets suspected to be Viagra tablets. Total approx 2000 suspected Viagra tablets. Weight of total tablets with black color cover plastic 212 grams. Weight of total
Okay,
tablets
let
with
us see the
without.
let us see the witness's statement.
So, my lord, for the next page 14, after completion of all the formalities, I, along with the staff, departed from the PO at 6:45 p.m. and returned to the Badarpur PS at 7 p.m. So it is done after sunset, but
No, no, we do not know 6:45 after SARS was done, they returned.
my lord,
Now that is
from
also
whom it was recovered, that was not cleared, my lord, in this FIR.
that
Shamim or
that you
Habib?
can argue. Therefore, let us see. It is not clear from whose possession it has been recovered because there are two bikes, two persons. Let us see the evidence of the that witnesses. PW1.
Yes, page 28.
Who is PW1?
PW1, my lord, Siddharth Malakar.
He was the
He is the Caesar witness.
Caesar witness.
He also denied mine.
Then PW2.
PW2 page 31.
Difficult. Okay. Who is the other witness? Now you have given it this, na? PW?
PW6 is another cigarette.
PW6.
Both were also not confirmed from whom it was recovered.
No, PW2 has confirmed it.
Yes. Clearly,
PW2 clearly confirmed it, equally from Bodda.
yes.
And that you have not challenged in the, not even says that this is a wrong statement.
Yes, in the cross part clause.
Look in the cross part. One evidence is sufficient and there is no contradiction. They says recovered. They have
Yes.
not mentioned, you ignore their evidences,
Lord.
then also PW2 remains.
My lord, may I read the cross part of the PW2?
Yes, read it. I have already read, but please read it.
Which contains my signature, there is no detail of the seized item. There is no details of the seized item. In exhibit PW2, PW1, PW3, PW1, no photograph shows me putting the signature in the envelope or any page. I do not know the address of Ojoy and Siddhar's house, but it is under Badalpur PS police, recorded my statement and wrote it down in my own handwriting.
These are not major
This is not,
contradictions.
but my lord, the seized details items seized, and not my lord, no the where he put his signature, the details of seized item were not given, my lord. It is not a fact that I did not state before the police that while getting down from the circle office, I saw gathering and that
You
police
know,
took
Mr. Chaudhary, you are a seasoned counsel. You know what should be our satisfaction at this stage. This may be a ground for your final argument with other evidences. But prima facie, we are of the view that they have been able to lay the foundation of recovery of this from them. Now onus shifts upon you. Your cross-examination is also not so happy. You have not even doubted the statement that no, nothing was recovered from us. Where is a suggestion in any of the eyewitnesses that there was no recovery? Nothing. You have not disputed that your bikes were seized and recoveries were made. You must challenge the evidence of the prosecution witnesses. There is no challenge. More particularly in a NDPS Act. Moment they lay the foundation, onus shifts upon you. You will have to rebut it. There is no cross-examination on PW2. Let us see once again PW6.
married PW6 man.
Hmm.
Incident took place 2 years ago at around 4:30 p.m. At Badalpur Ghat. I was in tea stall near Badalpur Ghat as employee. Police stopped 2 motorcycles and both riders. Police recovered 10 packets from them. The packets contains tablets, each packet contains 200
See,
tablets.
here also police recovered 10 packets from them.
Lordship.
Okay, the packets contain tablets, each packet contain 200 tablets. Now, whether it is there is one packet, two
My lord,
packets with, huh?
For the next line, my lord, police took my signature on blank paper.
Okay, police
Is
took
there
my,
a-
I read it, blank, and thereafter wrote in the paper dictating its contents to me. Will it be fatal? If you would have said, no, I do not know, they have taken my blank signature, that would have been different. He says he took me signature, thereafter dictated, and I know that what is dictated. So these are minor things that can be a part of your final argument. That their allegation that it was recovered from your position, you have raised doubt about so far relating to the procedure of seizure.
From whom, my lord, from whom it was seized, that
Ah.
was not identified. Two
Not,
persons,
no,
my lord,
not
two-
identified, understand, but one of the witness says specifically, other also says that yes, from both. Okay, you don't have any cross-examination that how many packet recovered, 2 or 1. Of course, definitely IO will come. You will have a scope. But on the basis of this, do you think this is a case for grant of bail?
My lord, 2 years, 2 months, my lord.
That you can
Although, my lord,
argue.
your lordship is saying that yes, IO, there is discrepancy which may be. So, my lord, on that footing, my lord, 2 years, 2 months, my lord, and although there was an observation of dishonorable court, considering my very young age, my lord, two persons, very young, 2 years, 2 months have been elapsed, my lord. I would any condition, my lord, I'll face trial, my lord. That is, although
Trial is almost over.
8 have been gone, my lord. There is observation of this court. my
Okay,
lord,
we'll think
considering
over
that
it. We'll think over it.
2 years, 2 months, consider this.
We'll consider, we'll think over it. Again, we'll go through it.
Very young in age, though, both of us.
That
Very
we have
young.
seen 24, 23.
Yes, my lord. And 2 years have gone, my lord. They arrested on 2021 age.
We'll see.
Sometimes, my lord, this is a motorcycle rider, my lord. Sometimes
Hearing
even some.
concluded for delivery of order on Friday.
Deeply obliged.
We'll go through it once again. We'll apply our mind. Otherwise, position is there. Okay, anyway,
Obliged.
it will it. Yes.
My lord, I've changed my laptop. Am I audible now?
Yes, yes, you're up to it. You have bought it or what?
No, 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 no. Cannot bought. It's urgent. I took my partner's laptop.
Yes.
Uh, I've already given the dates and the situation, how does it facts have arisen and related to file this writ petition, stating it to be how it is without jurisdiction.
Hmm.
So if your lordship is convinced on that part with respect to the facts and situation, I can take your lordship to the judgment cited by my friend, where my friend has stated that hotel will fall under manufacturing unit, and that is why it will be treated as a factory in view of a judgment pronounced by the Supreme Court. Honorable Supreme Court has stated in 93, but then there is no clear finding on that case. They just said for this case, we are saying that hotel, of course, you bring it under as a manufacturing unit and say it be a factory. So for that, if I am not disputing to that judgment, or I'm not even
That
trying.
is, you are saying GL hotels.
Yes, my lord.
GL hotels.
GL Hotel.
Hmm.
My friend has cited
Where are
that.
those judgments? Judgments are missing. Okay, you will have to. Anyway, we'll have it. Citations are there.
GL Hotel, and otherwise citation is 1993 4 SCC 363.
Your case will be, even if GL hotels are there, by notification, it was brought in this year, not prior to that, isn't it?
No, there will be another factor to it.
Yes.
Hotel said it's a factory.
Hmm.
If state government themselves are saying that it is not a factory, it's an establishment, can they in the year 2012 again come and say, no, it was a factory? In 2010 itself, they have specifically stated that hotel and restaurants are establishment. These fall in a different head. In the ESI Act, I'll show it to your lordship. Factory is defined differently, establishment is defined differently. Now, every state has a power to first bring ESI Act. The moment ESI Act comes into force, the factory, it will be applicable to factory. But for establishment, they'll have to notify it separately.
Therefore, those were no notifications were there.
Yes. Now, when they say it's an establishment, merely to argue before your lordship in an affidavit, they come and say that now I will rely on the GL hotel judgment. Because that was not the intent of the state government itself. Initially, they wanted to put it in hotel and establishment.
Hmm.
Subsequently, only to develop this case, today, before your lordship, they are saying that it will be covered under GL hotel. Otherwise, in the so-called notice itself, they could have said that you are covered by this judgment. And that is why you fall under factory. And my Lord Messi, in
Now,
2000,
which paragraph you are relying on this GL?
my friend is relying on that judgment.
No, that you are which paragraph you want to explain that this was not a ratio laid down, but
Para 7.
Huh?
Para 7.
Para 7.
It says, but the para 7, if we see in the next page 368, may I just read that particular, the object is to extend the welfare.
Which paragraph?
Next, para 7, next page 368.
Is given Manupatra. It starts with the observation in the aforesaid paragraph.
Manupatra, I have SCC
No,
on
just it starts on the observation in the aforesaid paragraph.
Yes,
Isn't it?
yes, my lord.
Yes,
The
read it.
aforesaid paragraph, namely, no part of the premises is used for purpose unconnected with the manufacturing process, has been strongly relied upon by Sri Saurabhji to contend that according to this code, the rest of the premises of the hotel must be shown to be connected with the kitchen activities, and unless it is shown, the rest of the hotel premises cannot be covered by the said act. There is no doubt that in course of explaining the activity which was under consideration in the said judgment, the court has made the observation in question to show how in fact even the activities carried on in the rest of the premises were also connected with the manufacturing process. The observation is, however, not the basis of the conclusion arrived at there. The observation has to be understood in the context in which it was made and cannot be interpreted to mean that in every case, such a connection has necessarily to be established in all respect. It is enough according to us that manufacturing activity has a broad connection with the activities carried on in rest of the premises. For example, in the present case, it cannot be denied that kitchen is an integral part of the hotel business. Those who occupy a hotel do depend upon the food and the beverage which are prepared in the kitchen. It is not possible to conceive of a hotel without a kitchen. Lodging and boarding are both essential components of services rendered by a hotel. Hence, it cannot be denied that the activity in the kitchen has a connection with activities carried on in the rest of the hotel premises. It should not further be forgotten that the definition of certain premises as a factory or of certain activities as an industry, etc., given in social welfare legislation like the present, are necessarily artificial. The object is to extend the welfare coverage to a large section of the individual as possible. Such definition cannot be tested on the anvil of the common users of the terms defined. The present is an illustration of the kind. At the same time, this is important, my lord. At the same time, the contention advanced by Sri Saurabhji cannot be dismissed lightly and may have to be seriously considered in appropriate cases. We are not accepting it in the present case because, as pointed out above, it cannot be said that kitchen activity has no relation at all with the activities in the other premises of the hotel. In the circumstances, we dismiss all the appeals with cost. Even otherwise, my lord, if it doesn't even say that only for this particular case, they have decided this ratio, but state government, by bringing out a notification, has themselves waived that part. Themselves has waived the applicability of this judgment for the state
Okay.
of Tripura.
Okay.
Now, Lordship has observed that in the preceding 12 months, there has to be 20 employees
Hmm.
during the period from 2009 March to 2010 March.
Hmm.
It is from their own notification. Now, if they apply this judgment, then that can be 10%. So whether they can do a pick and choose method to put some hotel and restaurant as a factory and some hotel and factory as an establishment. In my case, it has been pick and choose method, which will also violate my Article 14.
Okay.
So ultimately, my lord, they have for the time on the last occasion, their 100% reliance was on this judgment to establish it to be a factory. Now they cannot pick and choose both way. At times they say it to be factory and at times they say it to be establishment. For that, the establishment is defined separately in the ESI Act and factory is defined differently in the ESI Act. That is my humble submission before your lordship. And moreover, I'll not extend my argument from here on because this is the only explanation which I wanted to give to your lordship, that by this judgment, they cannot take the right in now before your lordship, which they have waived in 2010, 2011, and this show cause notice also 2012 is silent absolutely on the inspection date. They don't mention anything when inspection is carried out. For second notification also, before rising, I have shown it to your lordship. There is another notification for a separate period. There, although that 20 days or 20 persons or 10 persons will not come into force, but lordship may see in that so cause notice also, they have not stated whether they have done any inspection or not. They have not mentioned anything. There also, they have relied on 11 employees. In the affidavit, they say the inspection was carried out in 2008 when they did not have jurisdiction for that. And the same argument will also apply in case of Gemini Distillery. The second case, there I don't have any other case apart from the fact that inspection was carried out prior to ESI Act came into force in the state of Tripura. That's my humble submission before lordship. I'll not take much time on after that. And if lordship wants to put some judgment with respect to cause of action and
I wanted some because he has raised it.
I'll just give the citation of those judgments. I'll not take your lordship to all the judgments. For cause of action, my lord, rely on 2020-10
Just a minute.
My lord.
2020
10 SCC 766.
766. Paragraph.
From para 17 onwards, my lord, they have relied on all the previous judgments. That's why I have cited a recent judgment. They have cited
This
Mullah.
is 2020.
2020.
10 SCC.
766.
10
That-
SCC 766.
Yes, my lord.
2020 10 766.
Yes, my lord.
Yes.
From para 17, they have relied on several judgment, which shows what is cause of action and when cause of action 226 are taken on record. And also one judgment that is 2010 1 SCC 457.
2010,
1 SCC 457. Para 9.
457.
Yes.
Paragraph?
Para 910.
Okay.
And then, my lord, second issue that is on alternative remedy.
Hmm.
That is Whirlpool. Firstly, Whirlpool, that of course, Lordship is well aware. To 1998 8 SCC 1.
Whirlpool and
Whirlpool, that is para 15 of Whirlpool. 15, then 20, 21 from Whirlpool, that those will be the para. And there is a recent judgment of Godrej Sarali, that is 2023 SCC online SC 95.
just a minute, 2023 SCC online
SC
SC
95.
95.
And here also alternative remedy, they have discussed in details from para 4
Hmm.
to para 8.
Okay.
And finally, one last issue, whether because of the pendency of long litigation, a
Hmm.
case should be dismissed in a writ proceeding because of alternative remedy.
Hmm.
That is 2023 SCC online SC
SC
once. 2023 SCC online SC 13331. 1331.
paragraph.
Paragraph is 28.
Okay.
And on the same point, 2023 SCC online SC, only the page number is different, 1659. Para 10.
5 paragraph
10. And
page
1659.
1659 paragraph.
Para 10, 13, and 14. It says that if it is pending for a long time, in our case also it's pending since 2012. So that's my humble
Okay. Okay.
problem.
I'll request one thing, just 2-page kind of a list of
My lord.
dates, relevant pages of annexers, the notice dated so and so, how this proceeded, but we have recorded, but still I will want from you. And in 1 page, your arguments, bullet points, and the cited citations.
Absolutely. My lord,
You have three arguments. So this is just 1-liner or 2-liner, 1 page. 2 pages, you complete it. You
connected
also,
with
no?
the judgment.
Now we hear,
Connected with the judgment, I will relate the pointers.
just you give it, you can mail it, any mail, Amar Kotra mail. You just have the mail address and you can mail it, or you can send him to a junior, he can give a printout and give it to us. What we are proposing is we'll complete it today, but we'll again fix it for further hearing. Give on that day the notes. If possible, we'll dictate in the court itself. Or if not possible, we'll keep it CAV and we'll deliver it, say around 19th of August.
My lord.
Yes. Now let us hear him. If it can give it early also, before the next date, then we can come prepared if time permits, because I'm in a division bench, that's why.
But on the last occasion, I raised the issue of jurisdiction and
So you see, you raise your that point of
jurisdiction.
cause of action
Cause of action.
on that regard jurisdiction, then maintainability, then merit. You have all this together.
Before that, I'll just come on to the merit a little
Okay.
bit.
Okay.
When learned friending is relying on the notification, if your lordship may peruse my affidavit in opposition, the notifications which has been relied upon. Annexure A,
Just a minute.
page 14.
Okay.
I'm only trying to show the notification. If a lordship may come to next page, annexure B.
Annexure B. Yes.
The notification issued by the government of Tripura.
Hmm.
Again, the later notification which they have relied on at page 16. Also, it's been notification has been issued by the government of Tripura. So here I'm trying to point out that all the notifications which the ES Act came into force was issued by the notification of by the government of Tripura. If at all they're aggrieved, it is where I've already raised. If they're all have been aggrieved by the notification, they could have challenged this before the Honorable Tripura High Court. Here the notifications, the jurisdiction aspect comes. And regarding the
No, they are saying that they are not challenging these notifications. They are relying on rather.
They're relying on. That's what I'm again confirming. This notification is issued by the government of Tripura.
Tripura.
So the jurisdiction, whatever the cause of action arises, is in the state of Tripura. And the notification, if you're
Okay, so you're fundamentally the notifications
even
on
suppose-
on the basis of which the actions are purported to be taken are issued by the state of Tripura in exercise of power under ES
Yes,
Act.
Act, that's
Okay.
right. Even whether bad in or this is they are relying on it.
So therefore your case is Tripura
Yes.
and therefore it shows that
That is-
action is in Tripura,
Is
cause of
Tripura,
action.
Cause of action.
Because whole source of
The whole source of
conferring the power
Yes,
or
ma'am.
assuming the power is this notification.
whether power bad or good, it's been exercised through the state of Tripura.
Okay, next,
And if your lordship may peruse the ESI Act for a moment,
ESI Act. Employee state
yes, ma'am.
which provision?
Section 1,
Section
Section 1, madam. Section 1 and the relevant clauses I'll read out.
definition.
Before the definition, I'll just print out the act, the preamble.
Okay,
madam.
okay.
If your lordship has got the
Yes, yes.
an act, this act
Hmm.
is to provide for certain benefits to employees in case of sickness, maternity, employment, injury, and to make provision for certain other matters in relation thereto. Whereas it is expedient to provide for certain benefits to employees in case of sickness, maternity, employment,
No,
injury,
just a
and to
minute,
make
just a minute. Where are you reading?
the preamble, Malati.
Huh?
The top of the act, Malat. Well, I'm just trying to make point out the purpose for
No, no,
enacting this.
that
This is
I
for social
understand.
legislation, this is
Ah,
for the
social
benefits of the employer.
Social welfare,
Well,
is,
Dr.
no
Bell,
doubt
leave
about
this
it.
for a moment, Malat.
No doubt about that.
Malat. Section 1, subclause 1, subclause 2, Malat, it extends to the whole of India.
Hmm.
Malat,
Ah, It extends to whole of India.
and subclause 3, Malat,
Hmm.
it shall come into force on such date or dates as the central government may, by notification in the official gazette, appoint, and different dates may be appointed for the provision of this act and for different states for different parts thereof.
Hmm.
So my 2008 notification,
Hmm.
in which I have annexed in my affidavit in opposition, my lord,
Hmm.
that state of Tripura,
Hmm.
by the notification of 2008, the act came into force, my lord, in the state of Tripura, my lord,
Hmm.
by the central government.
Hmm.
So here's this, I'm trying to point out
Hmm.
that. And when relying on my other liberal submission would be that there is no cause of action
Hmm.
at the present. Assuming when leaving apart all the technicalities,
Hmm.
alternative remedy, the petitioner have already paid their dues, which were demanded by us. And that, which your lordship may also find it in my affidavit in opposition at page 19. In fact, they have admitted that yes, it comes under the provision of the ESI Act, and they have paid all the dues which are under challenge, my lord. Page 19 of my affidavit in opposition, my lord.
Page,
19, Annexure E.
just a minute. Okay,
Page 19, my lord.
yes.
The last paragraph, my lord. And this is a letter by the petitioners to the corporation. An elaborate discussion was taking place in the meeting from his honorable labor commissions and other speeches, when we would realize the actual necessity, seriousness, and applicability of ESI for the workers of farm. Accordingly, we made it understand to the workers when they become interested to insure themselves, and we also registered our workers under ESIC registration, and a contribution is being deposited in the employee state insurance fund after observing all the formalities. Now here, they have already paid the amount which was under the show cause notice. And your lordship may again peruse the ESI Act, my lord, section 1(6).
Then why don't you say that we are not going to take any action?
No, that's why I'm coming point about why we are taking action. If your lordship, they have admitted that it comes under the ESI Act, they have paid the contribution. Now, if your lordship may peruse the section 1(6), my lord, of the ESI Act.
Just a minute, which provision?
Section 1, subclause 6.
Section
1, subclause 6.
Yes.
My lord, a factory or an establishment to which this act applies shall continue to be governed by this act, notwithstanding that the number of persons employed therein at any time falls below the limits specified by or under this act, or the manufacturing processes therein ceases to be carried on with the aid of power. So here my summation: once the establishment or any other factory comes within the provision of the ESI Act, even it will be deemed to be continued, unless the exemption has been granted by the state government. And they have been seeking exemption. The exemptions can be granted only under section 87 of the ESI Act, my lord. So nonetheless, if
Just a minute, just let us read it. A factory or an establishment to
My lord.
which this act applies
My lord.
shall continue to govern by
By
this
this
act, notwithstanding that the number of persons employed therein at any time falls below the limit specified under the act or the manufacturing process therein. No, I think this will be interpreted as this. Suppose a factory or establishment
My lord.
comes within
The purview of the
purview
ESI.
of the act. Suppose they are having 21 employees or 20
Yes,
employees,
my lord.
it comes within.
My lord.
At any future date, if there is a reduction in
My lord.
employee, even it comes below
My lord.
20, they will
continue
continue to be covered. So in this sense, once it comes under, it will. So here in their case, they say that on the date of implementation of this act, we did not come. So therefore, this continuation will not be applicable in our case.
My lord,
Is that it?
Yes,
But
my
that
lord,
is just-
I need to correct why my friend is saying about this exemption, because they have promised themselves. He is suppressing that part.
Okay,
That
okay,
they-
okay.
That is a
we'll
different
go
aspect
there.
from basic. Why I'm making
I'll
a
show it
submission.
later.
Rightly or wrongly,
Hmm.
if the act, if any establishment come under the ESI Act, it will be deemed to be governed by the ESI Act.
No, there is a difference between coming into and not in terms of the act. Suppose on the date of initiation,
My lord,
today,
my lord,
suppose mandate of the act is that there should be
10 or
30
my
employees.
lord.
Only condition is 30 employees. Establishment or factory establishment below 30 you will not cover.
Is not covered.
Suppose
Hmm.
it is 30
My lord.
this year,
Hmm.
so it will come. Then it is covered under the insurance.
My lord,
3 employees is no more.
My
There
lord.
is 28
My lord.
next year.
my lord.
That will not exempt them
My
from the. I think this is the interpretation of this.
Yes,
case.
that is the interpretation. Why I'm saying, because my lord, the establishment of the petitioner
Hmm.
was bought, my lord, when there were 11 employees.
Ah.
There's a matter of fact, my lord,
Hmm.
which Lordship has already pointed out.
ah.
It's a matter of fact whether how many employees are present. As per our inspection, there were 11 employees. And at that moment of time, the 10 was the minimum number.
10 or 20?
10, my lord, for the manufacturing process, which I have also stated in my affidavit in operation.
For manufacturing.
No. That is my submission before.
Okay,
this
okay,
honorable court.
okay.
And exemption, my dear.
So therefore,
My-
when it is 11,
my lord,
even if it is
9 or
reduced
7,
7, that will
They
continue.
still continue to in today also, my
Oh,
lord.
okay.
If they are not seeking
Ah,
any
yes,
exemption.
yes.
And my lord, they are seeking exemption, may now come to the exemption part, my lord, where the exemption can be granted. Section 87, my lord. Of the
Section
ESI Act.
87.
87, my lord. Like, we may again issue this fresh show cause if they're still under the ESI Act.
87.
87, my lord.
Yes, exemption.
Exemptions of a factory or establishment or class of factories or establishment, my lord. My lord, if I may read out.
Yes.
The appropriate government may, by notification in the official gazette and subject to such conditions as may be specified in the notification, exempt any factory or establishment or class of factories or establishment in any specified area from the operation of this act for a period not exceeding 1 year, and may from time to time by like notification renew any such exemptions for period not exceeding 1 year at a time, provided that such exemptions may be granted only if employees in such factories or establishments are otherwise in receipt of benefits substantially similar or superior to the benefits provided under this act. And my section 88, my lord.
Just a minute.
My lord,
Section 80.
88, my lord. 88 from 87 to section 90. So 91, my lord, it's important, my lord.
88.
From 87 to 91, my lord.
Hmm.
I'll not read out the all, my lord.
Oh.
And exempt section 88, my lord.
Hmm.
The appropriate government may, by notification in the official gazette and subject to such conditions as it may deem fit to impose, exempt any person or class of persons employed in any factory or establishment or class of factories or establishment to which this act applies from the application of the act. Corporation to make representation, my lord, section 89, no exemption shall be granted, renewed under section 87 or section 88 unless a reasonable opportunity has been given to the corporation to make any representation it may wish to make in regard to the proposal, and such representation has been considered by the appropriate government, my lord. Without the consultation of the corporation, my lord, we have to be there, my lord. And 91A, my lord.
90.
1A, section 91A.
Just a minute. 91A.
91A.
Any notification.
Any notification granting exception under section 87, 88, or 90, or section 91 may be issued so as to take effect prospectively, my lord, on which date as may be specified therein. Suppose the exemption is granted today, my lord. So, my lord, the respective date, the earlier dues will have to be paid, my lord. Only it will be paid prospectively, not retrospectively. So that is my submission. My lord. Since they have already in their own representation, they have paid the
for
dues.
exemption.
My lord.
They sought
They
for
sought for the exemption, but the exemption has to be granted in
Given
the
by the
proper manner. The state government has to, and the state of Tripura,
not by the corporation.
my lord.
Corporation is to be hard.
Corporation is
Is
to be
to be
heard. The
heard?
exemption has to be granted by the state government, and the
By
state,
by way of notification.
my lord, and the state government is the state of Tripura, my lord.
Okay.
Yeah, and another limb of argument, my lord, the state of Tripura has not been implemented in this writ petition, my lord, government of Tripura, my, which is very much important for the education of the matter. Even if for the purpose of exemption, the notices, the notification, is all been issued by the state of Tripura, my lord. So again, time again, I've been, my lord, raising the issue of the jurisdictional point.
Okay.
Now again, coming back to the facts, my lord. These show cause notices, my lord, my learned friend has relied these notices. The first show cause at page 20 of my affidavit in opposition.
Yes.
He has relied on the dates, my lord, the contribution, the 11, my lord, the number of employees. My lord, here at page 21, I may read out, my lord, in the last paragraph. Whereas it is proposed to afford so and so an opportunity to show cause.
Where?
My lord,
And where is it is proposed to afford.
my lord, page 21. So, my lord, here, my lord, the submissions which have been made by this honorable court, they could have easily replied in the show cause notices, my lord. Here, my lord, page 21. Last paragraph, my lord. Has your lordship got it?
Yes.
And whereas it is proposed to afford so and so an opportunity to show cause against the said determination and recovery, and show cause within 30 days whereof as to why the assessment should not be made. So man, this is show cause, my lord, and without giving a reasonable opportunity, no determination can be made by the corporation, my lord. So the show cause was given, and reasonable opportunity was also given to them to file the reply, if any, regarding their grievances. So my humble submission is before this honorable court, whatever my friend has been submitting, the point of the argument would have easily, my lord, replied in the show cause notices. And for a moment, my lord, and after the show, this first show cause notices, at page 23, my lord,
Just a minute. Yes,
and after the show cause notices, since no reply has been submitted, then the order under section 45A has been issued, my lord. And my lord, what is section
that
45?
that is at page 23.
23, my lord, of my affidavit in opposition.
Yes.
And your lordship may peruse the section 45A, my lord. What is section
45?
45A of the ESI Act, my lord? Actually, lordship got it, my lord.
Just a minute.
No.
45A.
45A, my lord. Determination of contribution in certain cases.
Hmm.
Where in respect of a factory or establishment, no returns, particular registers or records are submitted, furnished or maintained in accordance with the provision of section 44, or any social security officer or other official of the corporation referred to its section so and so, my lord, provide, but a principal or the immediate employee or any other person in exercising his functions or discharging his duties under section 45, the corporation may, on the basis of information available to it, by order means determine the amount of contribution payable in respect to the employees of that factory or establishment. Now here it's important, my lord, provided that no such order shall be passed by the corporation unless the principal or the immediate employer or the person in charge of the factory or establishment has been given a reasonable opportunity of being heard. Yeah, man, a reasonable opportunity was also, it is a fact that they have received the notice, man, show cause notice, and reasonable opportunity was also given to reply the same, but which was not done in this case, my lord. And accordingly, the section 45A order has been issued, which your lordship will find at page 23. And in the order, it is also been reflected that the opportunity was granted, but still no reply has been furnished by the petitioner. And all the orders, my lord, here also, my lord, the order under section 45 is issued by the regional office in Tripura, as well as the show cause notice, which was identified and replied, my lord, from the regional office of Tripura, my lord. Now, my lord.
Now, what is the appellate provision against
But
this?
that after passing of the 45 order, the petitioner will have two remedies, my lord. And they have to raise the appellate authority, that is section 45 AA. National lordship. On a 45 AA.
45
AA.
double A.
It's a lordship.
Read.
My lord, the appellate authority, my lord. If an employer is not satisfied with the order referred to in under section 45A, my lord, here's the order. He may prefer an appeal to the appellate authority as may be provided by regulation within 60 days of the date of such order after depositing 25% of the contribution so ordered or the contribution as per his own calculation, whichever is higher with the corporation. Provided if the employer finally succeeds in the appeal, the corporation shall refund such deposit to the employee together with such interest as may be specified. So these are the two remedies, section 45AA
Or
and section 75, Malad, where it is the alternative remedy, Malad. What are the alternative remedies, Malad?
where are this, and
One
other is
Section
section
75.
75.
So he has the,
Just a minute.
Malad.
70?
75. Malad.
Yes.
Matters to be decided by the employees insurance board. If any disputed question arises as to, if your lordship then straightly come to G, Malad, I'm reading out. Any other matter which is in dispute between a principal employer and the corporation, or between a principal employer and an immediate employer, or between a person and the corporation, or between an employee and a principal or immediate employer in respect of any contribution or benefit or other dues payable or recoverable under this act, or any other matter as required to be, which may be decided by the employees insurance court under this act. Such question or dispute subject to the provision shall be decided by the employees insurance court in accordance with the provisions of the act. But here, this since there's a dispute, Malad, here it comes, Malad. Either he could have approached the appellate authority under section 45AA or the insurance court, Malad. And this honorable court, Malad, from time and again has been rendering such cases and been referring to the insurance court. I have placed few judgment, Malad.
Nothing is here.
But I'll place it again, Malad. Even after the passing of the order dated 21/3, Malad.
Kept it somewhere very nicely.
I'll just
No, it is here. It is here.
I'll show the judgment.
Your whirlpool is there.
Hello.
Who relied on 2007-11 SCC?
2007 that I relate, Malad. This CC Santa Kumar regarding this ESIC Act, Malad.
Okay.
And even after the order dated,
Then Kharsul Islam.
Malad, I relate. These are
Kharsul Islam. Then this is yours. ESIC versus CC Santa Kumar.
CC Santa Kumar. That is Malad Supreme Court, Malad.
And then Assam Railway Employees
Yes,
Cooperative
Malad. These are
Association.
by this honorable court, Malad.
Okay.
Malad, now, Malad, even after the passing of the order dated 21/3, Malad, by your lordship, there are 3 more cases which have already been passed by this honorable court. Malad, I'm relying on you, Malad.
Okay. Give us.
WPC number, Malad. 1687/24, Malad. 1687/24. Then lordship may come to paragraph 12, Malad. That above being there disputed question of facts involved, as can be seen from stand taken by the petitioner's counsel, that the petitioner is employing only 5 or 7 persons, while the respondent corporation has made the order dated 29/10/21 on the premises that the petitioner is employing 175 persons. This disputed question of facts cannot be decided in a writ petition. Further, there is a statutory alternative remedy available to the petition under section 75 of the Act. I've also noticed the various orders passed by this court in somewhat similar cases, wherein this court had directed a petitioners to avail the alternative remedy available under section 75 of the Act, Malad. The orders when here are the other decisions, Malad. And accordingly, Malad, para 13, Malad, in view of the reasons above stated,
I've read it. I'm very fast in reading.
Malad, then Malad, I would give 2 more judgment, Malad. Similarly, placed,
Okay.
after the passing of the recent judgment, Malad.
Okay.
I'll give it to my learned friend, Malad, WPC 3080/24, 24. And WPC 7863/2019. 7863/2019. On a similar footing, Malad. That's my submission, Malad. So, Malad, this is my submission that these matters, once it is open, it will open the Pandora's box, Malad, all the matters will be here. So, they are the liberty to go before the EI court.
Okay.
And they will remedy this, Malad. That is my message. And also on the jurisdiction point of view, that all the government, they have not implemented the state of Tripura party. So the notification are issued by the state of Tripura. So, Malad, and that is my honorable submission, Malad. And I'm not saying that this court cannot entertain.
No, that we understand.
Subject to.
This is a discretionary power when
Malad.
to be used. This is not this is self-imposed restraint.
These are my humble submissions before this.
Anything you want to add?
Only two aspects.
And
Nothing
I'll also, before,
just-
I'll also give a written argument. of
That,
point-
that you have
point.
give, if you can give it before
In-
next week.
Man, I'll give it by this week only. I'll give it, Mother.
Give it.
And also, I'll also give the all the other petition number here, Mother. Which are honorable court.
Yes.
only 5 minutes. I'll not take much time.
Hmm.
Regarding that,
What you say regarding that application
which application, brother?
that you have paid and all?
Yes, that is the important aspect, my lord. My lord, may kindly see what they have done. They have sent recovery notice to all the banks. They have prohibited my bank accounts. Stopped my bank account. What I could have done at that time. There was no option left for me. And then, my lord, kindly see my writ petition page number 46.
Page number
46.
46. Just a minute.
Yes, madam.
Page 46. Yes.
To UCO Bank.
Hmm.
Who has issued it? It's a Bamuni Moitam Guwahati office. That is what I have referred to with regard to cause of action. And Chief Engineer UCO Bank has been noticed. It says that please refer to your letter so and so on the above mentioned subject wherein you have been informed that the account has been freezed. So they have freezed. That is UCO Bank. Then my lord may say, next page, 47. Even the HDFC Bank, for 3 lakhs rupees, they have stayed my entire, freeze all the account. And
Just a
I'll-
minute.
Yes, ma'am.
Hmm.
Page 47 to the HDFC Bank. Again, recovery notice.
Hmm.
Then my lord may see one document which says in page 42. That's a minutes of meeting.
Page 42.
Yes, ma'am. My lord, my submission is it's a social welfare legislation. My friend is also suggesting that. So till 2012, they have not done anything for socially protecting the employees. No one is getting benefited. None of the employees is getting benefited. It's just a way to recover the money, which will help the state and no one else. In page 42, this is the minutes of meeting where all the establishment owners were called for. And there in page 43, my lord may kindly see, first paragraph, the ESI, local branch manager elaborately explained the facilities available in ESI for the employees from treatment facilities to cash benefit. He apprised that regarding treatment facilities to ESI, IP has no limit in any situation. ESI may spend any amount for the better treatment of an IP. In reply to the above points, the local branch manager mentioned that immediate regularization of payment of subscription by the defaulter owner is necessary. And regarding outstanding payment, he suggested to apply to Regional Director Guwahati for exemption. It was his suggestion. Now, my friend is relying on section 87, 88 to say that appropriate government will give an exemption. That's only that with respect to granting exemption to a establishment as a whole. Everyone will get the exemption. This is with regard to this particular individual. They said that you apply, you pay the money, you register yourself, and then we'll grant you exemption. And this meeting was called in 2013, 31/12/2013. That is end of the year. That almost is 2014. So why for 5 years they have not conducted such meeting to apprise the people that this kind of benefit is available? Our payment was made after this assurance given to us. And because of the prohibitory order where all the bank account has been freezed. And with respect to my friend's argument regarding the notification from Tripura and Tripura not made a party, in that case, my lord, if we rely on a central act, then in every case, Union of India has to be made a party and all the cases has to be filed in Delhi. So that cannot be the argument that merely because there is a notification from Tripura, so we'll have to make Tripura government a party, and also that we have to go and file a case before Tripura only. That's my submission on that point, my lord.
One lastly, my lord, only 5 minutes, 2 minutes, my
Yes.
lord. In regarding to the recovery method, my lord, if the notices are the recovery proceedings, my lord, where already reasonable opportunity was granted to the principal employer to come and show, just like the DRT, my lord, one day away has been finished, then recovery proceeding starts. There where it is acted. And regarding my lord, on one last judgment, my lord, I'll also submit on the point of non-joinder of necessary parties, my lord, because the Supreme Court, in 2009-10 SCC, I have only one copy. I'll just read out the 485. It is realized that in our opinion, whenever any petition is filed under Section 75, the employer has to only to implement not only to implement ESIC, but also has to implement at least some of the workers concerned in a representative capacity if there are a large number of workers or trade union representing the said worker. If that is not done and a decision is given in favor of the employer, the same will be in violation of the rules of natural justice. After all, the real concerned parties in labor matters are the employers and the workers. The ESI corporation will not in any way be affected if the demand notice is sent it under the Section 45B or 55B is squashed. So these recovery proceedings are for the benefit of the
Give
2009-10 SCC 485,
2000.
9-10 SCC 485, and Malad
9,
10
10
SCC
SCC
485,
485.
and also 2009-10 SCC 671, Malad. And I'll give it on Malad this judgment.
Give a note and give the judgment.
my lord.
We'll try to deliver this judgment on next Friday.
Malad.
If you can give it before.
My lord.
Okay.
My lord, I will also say how these judgments are not applicable. None of the
Okay.
cases are applicable in my
Okay,
case.
you give it
Yes.
written. These are, we are not giving so much importance to these issues.
My lord.
We are on
Indeed,
other
right.
part of this. Third in part, list it for further hearing on Monday, next Monday.
Next Monday, my lord.
Mm.
But I will submit the
In the
before,
meantime.
in the meantime.
In the meantime. Huh? It
By
will
Friday.
come by sleep, huh? So that I can go through the everything.
My lord.
Right. Refresh my mind.
Be okay, my lord, if we submit it by Friday?
By Friday, it's okay. But Saturday, Sunday, so
No,
that I
no.
can spend some time
My lord.
by sleep. Huh? Thank you.
Okay.
All right.